Welcome to my new video. Today we're going to discuss an important topic, trusts. If you've ever wondered what a trust is, how it works, and why it's important, then this video is for you. We'll break down everything you need to know, from the types of trusts to their legal aspects, registration process, and tax exemptions. So stay tuned till the end. What is a trust? A trust is a relationship in which a person or entity holds a valid legal title to a certain property, which is known as the trust property. The trust is bound by a fiduciary duty to exercise that legal title for the benefit of any one or more individuals or group of individuals or organizations who are known as the beneficiaries. The trust shall be governed by the terms of the written trust agreement, also called as trust deed. For more detailed information, visit the official website of VMK Professionals at vmkpros.com, and always review the latest amendments before execution, as laws keep changing frequently. Trust is defined in Section 3 of the Indian Trust Act, 1882 as an obligation annexed to the ownership of property and arising out of a confidence reposed in and accepted by the owner, or declared and accepted by him for the benefit of another or of another and the owner. In other words, it is simply a transfer of property by one person, the settlor, to another, the trustee, who manages that property for the benefit of someone else, the beneficiary. The settlor must legally transfer ownership of the assets to the trustee of the trust. Author of trust, the person who reposes or declares the confidence, is called the author of the trust. Trustee, the person who accepts the confidence, is called the trustee. Beneficiary, the person for whose benefit the confidence is accepted, is called the beneficiary. Trust property, the property which is bestowed onto the trustee to be utilized or hold for the benefit of the beneficiary. Types of trusts. The trust has been broadly classified as 1. Public trust. 2. Private trust. Public trust, when trust is constituted wholly or mainly for the benefit of public at large. In other words, beneficiaries in the public trust constitute a body which is incapable of ascertainment. The public trusts are essentially charitable or religious trusts and are governed by the general law. The provisions of Indian Trusts Act do not apply on public trusts. The Charitable and Religious Trust Act, 1920, the Religious Endowments Act, 1863, the Charitable Endowments Act, 1890, the Societies Registration Act, 1860, and the Bombay Public Trust Act, 1950, are the relevant legislations for the recognition and enforceability of public trusts. Moreover, in recent times, trusts can also be used as a vehicle for investments, such as mutual funds and venture capital funds. These trusts are governed by Securities and Exchange Board of India, CBE. Private trusts. A trust is called a private trust when it is constituted for the benefit of one or more individuals who are, or within a given time may be, definitely ascertained. Private trusts are governed by the Indian Trusts Act. Public trust vis private trust. The criterion for deciding whether a particular trust is of private nature or not is whether the said trust is for the benefit of certain individuals or not. Where the intention of the founder was that the property was to be dedicated for the benefit of idols, the trust is undoubtedly of a public nature and not for the benefit of the individual members of family. The essential difference between a private and a public trust is that in the former, the beneficiaries are definite and ascertained individuals, or individuals who within definite time can be definitely ascertained. But in the latter, the beneficial interest must be vested in an uncertain and fluctuating body of persons, either the public at large or some considerable portion of it, answering a particular description. For more detailed information, visit the official website of VMK Professionals, www.vmkpros.com, and always review the latest amendments before execution, as laws keep changing frequently. Persons who can create a trust. A. Any competent person. B. Company. C. Trust by a woman. D. Association of persons. E. Hindu undivided family. F. By or on behalf of minor with the permission of civil court. Persons who can be a trustee. Sec. 10. Any person who is capable of holding property may be a trustee. Duties of trustee. Sec. 11 to Sec. 22. Duties of trustee are as under. Proper execution of the trust as per the directions given in the instrument of the trust deed. Acquaintance with the nature of the trust property, so as to do justice with the trust and its purpose. e.d., protect and preserve the trust property, not to set up an adverse title. V. To deal as a man of ordinary prudence would deal with such property as if it were his own. VI. To convert the property of a wasting nature into that of permanent nature. To act impartially or in favor of all beneficiaries. In case of a trust created for several people in succession, if one person is doing something injurious to the trust property, the trustee needs to take preventive steps. Ix. To maintain accurate accounts of the trust property and to invest the trust property and funds in the eligible securities. X. To sell the trust property with authority by the court. Powers and rights of trustee. Powers of trustee are as under. 1. Selling the trust property if allowed by trust deed. 2. To vary or alter investments as per the requirements of the situation in interest of beneficiaries. 3. To apply the trust property or income generated from it for the maintenance of the trust property itself. 4. To settle claims unless a contrary intention appears from the instrument of the trust. 5. To give receipt for the money received on account of the trust. In case of death of one of the trustees, the other trustees have a right to act unless a contrary intention appears from the instrument of the trust. Exemptions available to charitable and public trust. Section 10 of the Income Tax Act, 1961. Total tax exemption is available for certain types of trusts if both the following conditions are satisfied. The activities of trust shall be related to sports, education, scientific professions, or promotion of khadi and village-based industries, hospitals, etc. They shall be notified as charitable or religious institutions. Section 11 of the Income Tax Act, 1961. If the trust is for any religious or charitable purpose, then any income, profits, or gains earned by such trust from a property held by the trust shall not be included in the total income of the trust. Section 12 of the Income Tax Act, 1961. Income received by way of voluntary contributions towards the corpus of the trust shall not be taxable. If charitable trusts are created for the benefit of any of the socially and economically backward castes, such as scheduled castes, scheduled tribes, or women or children, then its income shall be exempt from tax. For more detailed information, visit the official website of VMK Professionals, www.mkpros.com, and always review the latest amendments before execution, as laws keep changing frequently. Procedure for registration of trust. 1. Creation of a trust deed. A trust deed may be created using any language sufficient to show the intention. It has following contents: name of the author settlor of the trust, name of the trustee, name, if any, of the beneficiary or whether it shall be the public at large, name by which the trust shall be known, place of principal and other offices of trust, the property that shall devolve, an intention to divest the trust property upon the trustee, object and purpose of the trust, procedure for appointment, removal, or replacement of a trustee, their rights, duties and powers, etc., rights and duties of the beneficiary, mode and method of determination, dissolution of the trust. 2. Signing of deed. The deed must be signed by settlor, author, and trustees in presence of at least 2 witnesses. 3. Printing the deed on stamped paper. Print the trust deed on appropriate value stamped paper. 4. Registration of the deed. Registering the deed with the sub-registrar at the time of registration. The settlor and witnesses must be personally present with their identity proof in original. 5. Application for PAN and bank account. After registration, trust should apply for PAN and opening a bank account. And that's all for this video. We hope you learned something new about trusts, how they work, their types, benefits, and the registration process. Let us know in the comments about your experience with trusts or if you have any questions. If you found this video helpful, don't forget to like, share, and subscribe to our channel. Also, hit the bell icon so you never miss an update. See you in the next video.